Good morning, this is your Kelso Report for Wednesday, September 5th, and I'm your host, Clark Kelso. In today's cases, we learn about the limits of consent to sexual contact in a prison setting. We get a reminder about the doctrines of exhaustion of administrative remedies and deference to administrative agency decision-making, and we have a somewhat far-fetched attempt to use the right to travel to avoid vehicle registration and driver's license requirements. Well, we begin with the Ninth Circuit. The fires of romance burn just as brightly in prison, but when the romance is between a prisoner and a guard, different rules apply. So says the Ninth Circuit in Wood v. Beauclair, where a male prisoner filed a Section 1983 action against a female guard and the state, alleging a violation of the Eighth Amendment based on the guard's alleged sexual abuse of the plaintiff without his voluntary consent. The complaint acknowledged that there was a romantic but non-sexual relationship between the plaintiff and the defendant. But according to the complaint, the defendant forced the plaintiff into unwanted sexual contact. The district court had granted summary judgment to the defendants on the Eighth Amendment claims, finding that the romantic relationship between the plaintiff and defendant was consensual, and therefore the plaintiff implicitly consented to the guard's sexual conduct. The Ninth Circuit reversed, holding that because of the enormous power imbalance between prisoners and prison guards, the law presumes that a prisoner's consent to sexual conduct in prison with a guard is not consensual, and the burden is then placed on the defendant to prove consent. The panel rejected the more extreme rule adopted in some other circuit courts that prisoners are per se incapable of consenting to sex with guards. At the same time, however, the court was concerned that simply allowing consent to be raised as an ordinary issue would not sufficiently account for the power imbalance. Accordingly, the panel held that when a prisoner alleges sexual abuse by a prison guard, the prisoner is entitled to a presumption that the conduct was non-consensual. The defendant may rebut this presumption only by showing that the conduct involved no coercive factors, including such things as any type of favors, privileges, or any type of exchange for sex. On the facts presented, the testimony from the prisoner was that he had expressly and repeatedly objected to the sexual contact, and the defendant could produce no objective evidence of consent to the contrary. The panel reversed the district court's order granting summary judgment to the defendants and remanded for further proceedings. Given the Ninth Circuit's rule, it looks to me like the defendants should at this point settle the case pretty quickly, because they are in a losing position. Now we have two administrative law cases. The first involving the doctrine of exhaustion. One of the cardinal principles of administrative law is that a court will require exhaustion of administrative remedies before entertaining a lawsuit challenging final administrative action. This rule ensures that courts do not involve themselves prematurely in what may not be final agency action. There are exceptions, of course, such as when exhaustion would be futile, but the exceptions are narrow and rather sparingly applied. A good example of the exhaustion requirement can be found in the Ninth Circuit's decision in Autotel v. Nevada Bell Telephone. The underlying dispute was between two telecommunications carriers. The plaintiff was a commercial mobile radio service provider wishing to provide wireless service in and around Pahrump, Nevada. It sought digital interconnection with the facilities and equipment of the defendant, which was the incumbent local exchange carrier in the area. As a matter of federal communications law, local exchange carriers have an obligation to provide reasonable access to other carriers. This time, however, after the parties' efforts to negotiate an interconnection agreement failed, the plaintiff sought relief from the Nevada Public Utilities Commission. Unfortunately, the plaintiff was proceeding without a lawyer and twice filed papers that were procedurally defective under state law. and which the state PUC rejected without reaching the merits. Frustrated, the plaintiff then brought suit in federal court, alleging that the defendant had refused to negotiate in good faith. The Ninth Circuit agreed with the district court that the plaintiff had failed to exhaust its administrative remedies. The dismissal by the state PUC was based entirely on procedural defects in the papers that were readily correctable. The plaintiff argued that requiring it to go back to the PUC was futile, but the Ninth Circuit was having none of that. The problem here was not that the agency was unwilling to entertain the plaintiff's claim. The problem was the plaintiff had failed to follow clear procedural requirements for getting the claim before the PUC. So the Ninth Circuit dismissed the appeal and sent the plaintiff back to the state PUC to exhaust its administrative remedies. Well, once an agency decision finally gets before a court for judicial review after exhaustion, one of the first and foremost important questions is whether the court should give some level of deference to the agency decision. What's the standard of review? Arguably, the agency itself is in the best position to interpret the statutes that pertain to the agency's mission, and the agency presumptively has some level of expertise in its subject matter area to which a court should defer. And when it comes to the agency's own regulations, who better to deliver a definitive interpretation? Over the years, the Supreme Court has recognized that courts should defer to agency interpretations on a variety of matters, what has become known generally as Chevron deference. At the same time, courts must resist becoming mere rubber stamps for agency decisions, particularly where the agency's position is not one of long standing and has the look and feel of a position that has been manufactured recently solely for litigation purposes. That was the key question before an in-bank panel of the Ninth Circuit in Price v. Stevedoring Services, where the underlying issue was whether a claimant under the Longshore and Harbor Workers' Compensation Act is entitled to the maximum compensation rate from the fiscal year in which he becomes disabled, or from the fiscal year in which he receives a formal compensation award. But before getting to those issues, the majority had to decide how much deference to give to the litigating position of the Director of the Office of Workers' Compensation Programs. Prior Ninth Circuit authority required that the court give Chevron deference, highest level of deference, to that litigating position. But the in-bank panel overruled those cases, concluding that, quote, our rule mandating deference to the director's reasonable litigating positions cannot be reconciled with Supreme Court precedent, close quote. In particular, the Supreme Court held in 2001 in United States v. Meade that Chevron deference applies only when, first, it appears that Congress delegated authority to the agency, generally to make rules carrying the force of law, and second, the agency interpretation claiming deference was promulgated in the exercise of that authority. A position taken in litigation does not qualify as an interpretation promulgated in the exercise of the agency's policy-making authority as a general matter, and therefore is not usually entitled to Chevron's heightened degree of deference. Now, this is an important administrative law decision because agencies have in recent years become overly reliant upon Chevron deference as a litigation weapon. The Ninth Circuit's opinion in Price makes sure that Chevron deference is limited to those situations where Congress probably intended the agency's decision-making to be given special attention. Finally, we turn to a California Court of Appeal decision involving the right to travel. Now, as a general matter, absolutist arguments in the law usually fail, since virtually every right or privilege comes with some conditions or limitations on use. For every rule, there is an exception, and this is true whether the right or privilege is grounded in the common law, statutes, or the Constitution. In Halagian v. D&B Towing, the plaintiff, a professed free inhabitant of the California Republic, had refused to register his light-duty truck and refused to secure a driver's license because, in his view, those requirements could apply only to someone who used vehicles and the roads commercially in a business for hire, for example, a taxi cab. In his view, private use of vehicles and roads was beyond the state's power to regulate, and California's requirements of vehicle registration and possession of a valid driver's license violated the right to travel, which he argued was absolute. Well, he was subject to a traffic stop where he was placed under arrest, and his truck was impounded and towed away to a private lot. 40 days after the impoundment, he finally paid the towing company a $1,300 fee for release of the truck. But then he turned around and sued the towing company, alleging that the impoundment constituted an illegal conversion of his truck. The 5th District Court of Appeal rejected the plaintiff's claims. Almost 100 years ago, the United States Supreme Court in Hendrick v. Maryland held that a state may regulate the operation of motor vehicles on its highways by requiring the registration of vehicles and the licensing of drivers. Updating that analysis, the 5th District concluded that the registration and licensing requirements are reasonable regulations that have only an incidental impact upon the right to travel. In addition, the seizure of the unregistered vehicle was justified under the so-called community caretaking exception to the 4th Amendment's warrant requirement. You can keep the community clean and safe. In this case, if the officers had not ordered the impoundment, the unregistered vehicle would have been left unattended in a grocery store parking lot, posing a risk of vandalism or theft. Accordingly, the towing company was legally justified and privileged to tow the truck at the request of the police officers and store it on its lot until the owner paid the appropriate fees. In this case, the plaintiff's unjustified absolutism cost him a pretty penny. And that's it for today's Kelso Report. Have a great day in the law.